grading the lawyers in yesterday's impeachment trial opening. Jamie Raskin, my former student, he gets an A-. His presentation was excellent, but he was wrong. Just dead wrong. David Schoen, he gets an A+. I think he presented the arguments effectively. He presented them strongly. He didn't deviate. And he was right to the point, and I think he was correct. Castor, I guess the best I could do is an incomplete. I didn't hear the argument. I didn't understand the theory. Maybe today we'll see more and better, and we'll hear my analysis of all of yesterday's proceedings on the Dershow. My assessment of yesterday's trial, beginning of the trial, I have to tell you, it was not a stellar performance all around. Jamie Raskin did a credible job for the House managers, but he was just fundamentally wrong, and he was proved wrong today. His focus was on the January exception. If a president commits a crime or does something wrong in January, the Trump defense lawyers would give him a January exception. Total, complete nonsense. Read the headline in today's New York Times. Here, I'll read it to you. It says that the Georgia authorities have opened a criminal investigation of President Trump, former President Trump, for his phone call in which he asked the Secretary of State to find votes. I think he'll be acquitted, but nonetheless, that's the option. That's the constitutional option. The Constitution says explicitly, when a president's been removed from office, he can be investigated and indicted. The feds can investigate him if he committed any crime. There's no January exception. All we have is a provision of the Constitution, which is as clear as it can be. The president, not a president, not a former president, the president and all civil officers shall be removed from office on impeachment and conviction. The president. How can it be any clearer than that? Congress has no authority to try anyone but the president, vice president, and all civil officers. If you have any doubt what that means, listen to James Madison, the father of the Constitution, who said in Federalist 37, you have to be a sitting president. Impeachment only operates if you're in office. It doesn't operate once you've left. The sole function of impeachment is to remove. Once you've been removed, you can also be disqualified, but you can't be disqualified unless you're first removed. The constitutional provision is so clear. Jamie Raskin, my former student, made a very strong emotional pitch, talked about his family in the Capitol. I felt very sympathetic toward him, and I'm sure the senators did as well. But his substantive argument just failed to convince. Oh, it convinced 56 senators. That doesn't mean it was right. The president can't be impeached once he leaves office. Congress acted above the law. Congress simply didn't feel bound by the text of the Constitution. And the text of the Constitution governs. And you don't resolve doubts in favor of broadening the power of Congress in impeachment. You resolve them by narrowing the power. That's the principle of lenity that operates whenever punitive sanctions are in existence. The principle of lenity says when there are two plausible constructions, you always use the one more favorable to the person who's being prosecuted, impeached, punished in any possible way. And so even if there were doubts in what the Constitution means, and the doubts that the House managers say grow out of another provision of the Constitution that says judgment in cases of impeachment shall not extend further than to remove from office and, not or, and disqualification to hold further office. So once you've removed, you can disqualify, but you can't disqualify somebody who hasn't been removed, who's already out of office. Otherwise, you could go after Nikki Haley and Bill Clinton and you name it, anybody. And that's what the House managers say. They say they have a roving commission, that impeachment gives them the power to go after anybody who ever held office in the United States as long as they're still alive. That's not what the Constitution gave them. Some state constitutions gave that power, not the United States Constitution. So Jamie Raskin's argument was compelling but wrong. now we turn to the Trump defense team. I don't know what to say about Attorney Castor. I guess I'm not smart enough to understand the subtlety of his argument. He was just schmoozing. He was sitting on a Cracker Barrel talking to a bunch of guys and saying, I like the senators. They're really good guys. I know a couple of the senators. I know they're terrific guys. And by the way, the First Amendment, I know it really does cover this conduct. It wasn't really an argument. I'm told he's a very good lawyer. It reminds me a little bit of Patrick Mahomes. Patrick Mahomes, the great quarterback, maybe the greatest quarterback in the league today, has his worst game, the worst game of the season, he has on Super Bowl Sunday. He didn't score a single touchdown. You can blame it on his line. They didn't give him a lot of protection, but it was his worst game ever. And this lawyer, I can't imagine that this was not his worst performance ever. Now, David Schoen came up and picked up the ball. He picked up the fumble, and he didn't run for a touchdown, but he certainly made a lot of yards. And so Schoen made a great argument. He focused on that provision of the Constitution, the president, vice president shall be removed. And he focused on other arguments that were very, very strong. He didn't know about the Georgia investigation. I would think that would be a prime subject for discussion today. Of course, they already voted that they have jurisdiction, 56-44, with one new Republican joining in this unconstitutional act. But there is no January exception. There just is no January exception. And if there were to be a January exception, it'd be in the Constitution. It would be the fault of the Constitution. You can't just interpret the Constitution to make it come out any way you want. I'll give you an example. When the framers sat down to write the impeachment provisions, they talked about a range of problems that could occur. One of the problems that could occur with the president, why you needed impeachment, was what if he became incapacitated? What if he had a heart attack? What if he was shot? What if he became incapacitated and was still alive? They said that's a reason why you need impeachment. But then they came to give the criteria for impeachment, and they didn't put incapacitation in. They didn't put that in. They said treason, bribery, other high crimes and misdemeanors. That doesn't include incapacitation. They left it out. And so for 100 and something years, we had a flawed Constitution that didn't have a provision dealing with incapacitation. What did we do? We amended the Constitution. The 25th Amendment says, now we're going to deal with incapacitation. Same thing is true with January exception. If you think there ought to be an ability to impeach a president after he's left office, amend the Constitution. There's a provision for it. Read it. It's right in the Constitution, how you amend it. But you can't amend the Constitution just by having a vote of the Senate. That's not the way to amend the Constitution. The Senate is limited to removing the president, not a president, not a former president, the president. If you don't believe me, listen to James Madison. If you don't believe him, listen to Chief Justice John Roberts. He understood the Constitution. He says, I'm not sitting on this trial. This is not a trial of the president. The Constitution says if the president is put on trial, the Chief Justice must preside. The Chief Justice is not presiding. It's not the president. It seems to me that is such a simple argument, and yet scholars all over the country say I'm wrong. I'm used to that. I've been bucking scholars at universities, at law schools for 55 years, and I've turned out to be right most of the time, and they've turned out to be wrong most of the time. I'll never be influenced by petitions and letters, no matter who the signatories are. Some of them don't even read it. Others wouldn't pass the shoe on the other foot test. Some are legitimate and genuine. They really believe their views, but their views are wrong. And we'll hear more about that today, because today we're going to hear about the First Amendment. Now you have 144 scholars threatening David Schoen, threatening the lawyers for Donald Trump, saying, if you dare offer a First Amendment defense, you will be committing unethical, unprofessional conduct. You will be engaging in legally frivolous arguments. The worst thing you can say about a lawyer, making a legally frivolous argument. I have won a lot of cases. I've lost some. I've never made a frivolous argument. I've been told on occasion, I remember in the Klaus von Bülow case, one of my associates suggested an argument that we should make. And my other associate said, no, that would be frivolous. That would be frivolous. Don't make that argument. I looked at the argument. I said, I'm not persuaded by it, but I don't think it's frivolous. Let's put it in the brief. We won based on that argument, on an argument that a lawyer thought would be frivolous. Lawyers are obligated to put in their briefs and to make arguments that are plausible and that are reasonable. And any lawyer who failed to make the First Amendment defense would be engaging in unethical behavior. Can you imagine getting up and defending the President of the United States, the former president in this case, who had a strong First Amendment issue, who made a speech, who was being impeached because of a speech, and you say, senators, I have to tell you, I'm not going to make the First Amendment argument. I'm not going to make it. It's a legally frivolous argument. I'm not going to make it. You should be disbarred if you refuse to make that argument in this context. Failing to make an argument is failing to provide zealous advocacy. I am still shocked. I can't get off this issue. I am still shocked that 144 law professors, including several of my colleagues, Lawrence Tribe, Charles Freed, Martha Minow, the former dean of the Harvard Law School, would tell lawyers that they could not make a First Amendment argument without violating legal ethics. That if they made a First Amendment argument in the context of the impeachment of a former president for a speech he made in Washington, D.C., he would be engaged in legally frivolous conduct, and no reasonable scholar or jurist would make that argument. Well, look me in the eye. I am a reasonable scholar and jurist, and I am making that argument on television. I'm making it in the court of public opinion. And if I were to have been former President Trump's lawyer, believe me, I would be making it in front of the Senate. You know what I'd be doing? I'd be reading your statement in that letter, saying I'm not allowed to make the argument. And I would have made it right then and there, right in the face of that letter, and told the senators, this is nonsense, this letter. The idea that you can't make this argument. This is a compelling First Amendment argument. After all, what does the Constitution say? It says Congress. It doesn't say state legislatures. It doesn't say the president. It says Congress. Congress, the people who are sitting there. Congress shall make no law abridging the freedom of speech. And the Supreme Court has interpreted no law as no action with consequences. So Congress cannot take an action that abridges the freedom of press and the freedom of speech. And were they to convict a president for a speech that's covered clearly by the Brandenburg Principle that distinguishes between incitement and advocacy, they would be violating the First Amendment. The president did not incite. What he did was to invite. There's a big difference between inciting and inviting. The president said, go, I urge you. It's an invitation. I urge you to go to the Capitol. Take back our government. I urge you to do it peacefully and patriotically. Most of the people listening didn't accept his invitation. They said, no, thanks. We're going to go home. We heard you speak. That's fine. Most of the people didn't go to the Capitol. Most of the people who went to the Capitol didn't break into the Capitol. Most of the people who broke into the Capitol didn't destroy property. Most of the people who destroyed property didn't hurt human beings. So he wasn't shouting fire, even though I hate that expression. When you shout fire in a crowded theater, everybody leaves. That's a message to the legs. Don't think about it. Leave. That's not what happened. The president made a speech. Some people listened, some people didn't. Invitation, not incitement. Not to make that argument? So I think we'll hear that argument today. It may be rejected. It may be accepted. But it has to be made. I hope David Schoen will make that argument because I think he made a very effective argument. There's a third lawyer on the team. I don't know that lawyer. Maybe he too will make an effective argument. Now, you know, when Mahomes did not do a good job, Reed didn't bench him because you don't bench your quarterback except under extreme situations. Castor is the quarterback. He described himself in his opening as the lead lawyer. So I doubt that former President Trump will bench him, but he has to shape up. He has to focus. He has to be laser-like. Maybe it's just a difference in style. He's comes from a different part of the country, a different background. It's just so not my style to schmooze the senators and schmooze the audience. My style is directly to the point. Here's the Constitution. Here's what it says. Here's what your obligations are. Do it. Do the right thing. You took an oath. That's the way I've won cases. Maybe he's won cases differently. So we'll hear what happens today. Today, I think there'll be a lot of focus, mostly by the prosecution, by the House managers, on why the First Amendment isn't applicable. I think they'll make two arguments. They'll make the first argument, wrong as could be, that the speech itself wasn't covered by Brandenburg. How you can make that argument, I don't know. Brandenburg himself, Clarence Brandenburg, a Klansman, a neo-Nazi, surrounded by people with hoods and crosses and who knows what else, guns, says to the people to go to Washington, not today, not tomorrow, but at some future time, and says we have to take revengeance against the senators, and we have to send the Jews back to Israel and the blacks back to Africa. A blatantly racist speech. Supreme Court unanimously says, no, that's a terrible, terrible speech. But it's protected by the Constitution, just like flag burning. Hateful. Flag burning is protected by the Constitution. Nazis marching through a neighborhood of Holocaust survivors, protected by the Constitution. The Chicago 7, blood on the streets, protected by the Constitution. Bruce Franklin making a speech in front of the Computation Center saying it's a good idea for you to take over the Computation Center. It's an act of war. The students then take over the Computation Center. The ACLU asks me to defend that case on the ground that it's protected by the First Amendment. So I don't know how they're going to get around the case law on the First Amendment. We lived through a golden age of the First Amendment from 1960 approximately to 2000, when we saw expansion after expansion of the First Amendment. The Pentagon Papers case, New York Times versus Sullivan, Falwell versus Hustler, a range of cases expanding the First Amendment. And now we're living through a period where we're seeing progressives and the social media trying to constrain the First Amendment. We're living through a tarnished age now, and I hope the Senate doesn't tarnish the First Amendment even further by actually coming to the conclusion that citizens of the United States are not allowed to make the kind of speech that President Trump made on January 6th. The speech was completely protected by the Constitution. It's the kind of speech you hear in the Capitol all the time. You hear it from labor leaders. You hear it from union people. You hear it from suffragettes. You hear it from radicals on both sides. You hear it from civil rights leaders. The language is common. And the Trump team played some videotapes yesterday. Maybe they'll play more of Congresswoman Waters provoking, inciting, really inciting. I think she's protected too, but she comes much close to inciting. Don't let them eat. Don't let them be peaceful. Provoke them. Get in their face. Tell them you can't just be a reasonable person and have a meal without us disrupting you. And other Democrats using fighting words. Fighting words are part of what we as Americans have listened to from the beginning of our experience. Our revolution was based on fighting words. In the run-up to the Civil War, both sides used fighting words. During the Vietnam War, we heard fighting words on all sides. That's part of what the Constitution protects. And so I hope that we won't see the Senate vote to pull back and constrain the First Amendment. The second argument they'll make is that, even if the First Amendment applies, even if Mr. Trump could have made that very same speech, it doesn't apply to President Trump because this is really an employment case. This is not a criminal case. It's an employment case. We're firing him. No. The framers of the Constitution rejected the analogy to firing. That was the British experience. In Britain, you could fire a prime minister. Simple vote of no confidence. Get one vote less than the majority, prime minister's out of there. That's not the American experience. James Madison rejected that. He said it would have the president serve at the pleasure of Congress, and that's not what he had in mind. He wanted the presidency to be strong. It's a republic if we can keep it. And therefore, they put provisions in the Constitution requiring conviction, 2/3 vote, treason, bribery, other high crimes and misdemeanors. This is not an employment decision. The president can fire a cabinet member. That's his prerogative. He can fire him for any reason or for no reason. But you can't fire an elected president unless he commits impeachable offenses. And for it to be an impeachable offense, it can't be a speech protected by the First Amendment. That seems to be so self-evidently clear to me, but not to the 144 scholars who think it's not even a plausible argument, that my argument is utterly irresponsible, that no scholar or jurist who is reasonable or responsible would make that argument. This is a new form of McCarthyism that we're seeing. It's designed to chill freedom of speech. It's designed to chill advocacy. It's like the McCarthyism I lived through as a kid. If a lawyer makes an argument in favor of a communist, that's unethical. If a lawyer makes an argument that we think is unpatriotic, that's unethical. Well, no, I'm a lawyer. I'm not listening to you scholars. I'm going to make arguments that I think and that the law says are reasonable and permissible, and arguments and defenses under the First Amendment fit into that category. So we'll listen. We'll hear. Today we'll hear the House manager's side. And then at the end of the week, we'll hear the defense side. I hope we'll hear it presented effectively. As a lawyer, I appreciate good advocacy, even good advocacy from people that I disagree with. So let's hope that today the level of advocacy is better. Let's hope that the presentation by the House managers is fair, and that when they present, for example, the speech of the president, they don't exclude the part where he said peacefully and patriotically. That would be unethical. When you present a piece of evidence, according to the law, you have to present all the evidence, the part that helps you, the part that hurts you. There's a concept in the law that you can't just pick and choose from a tape recording the way CNN did with me. When you're in front of the Senate, you have to be fair. And so I think the whole speech should be presented. And I think the evidence should be seen that also shows how much preparation went into the horrible, horrible invasion of the Capitol building, and whether or not the people who made the plans to break into the Capitol building were in fact influenced by the president's speech. Maybe they were influenced by what the president said generally, challenging the election, but that's constitutionally protected. Jamie Raskin challenged the 2016 election. I challenged the 2000 election. I wrote a book about it called Supreme Injustice. So you certainly have a right to challenge an election. So let's hear how it unfolds today. Let's see if Castor is benched or continues to be the lead counsel. And in the end, let's just hope that the Constitution is not compromised in the name of partisan political expediency. If I were to write a book about this current impeachment trial in the Senate, I would call it Hamilton's Nightmare, because Hamilton in Federalist 65 said the greatest danger lies in impeachment proceedings that are based on how many votes you have, that are based on partisanship, that are based on who has the most senators voting on their side, rather than on complying with the words of the Constitution and listening to the evidence. So let's hope that Hamilton's great danger does not come into fruition. If it does, we'll be talking about it. We'll be discussing it. We'll be following the impeachment trial until it's over. You'll hear it here on The Dershow. Let's start with our first call for today.
Hi, Professor Dershowitz. This is Will Hupp from Chicago, Illinois. My question is, what would it take to make secession of a state legal? Would it require a constitutional amendment, or could Congress just pass a law? Thanks very much. Appreciate the content and wish you all the best. Thanks.
What a great question. I've thought about that a lot. What would have happened in 1860, after President Lincoln is elected, if the southern states had just said, we hereby secede. In fact, if they had written a Declaration of Independence, when in the course of human events it becomes necessary for one group of states to secede from another, due respect for humanity requires that we set out our reasons. And then Calhoun and others set out the reasons for secession. No attack on Fort Sumter, no declaration of war, simply a decision by the state legislatures to secede. Fascinating question. I don't know. Would the North have invaded them? Would they say you can't secede? Or would they have accepted the secession? We'd have two countries now. We'd have the Confederate States of America, and we'd have the United States of America. So nobody knows the answer to that question. Obviously, if Congress passed a statute saying you're allowed out, I guess it would be valid. But I can't imagine that ever happening. But I remember when there were some issues about nuclear weapons and everything. I remember Martha's Vineyard, where I live a lot, and Nantucket thought about seceding and starting a new country called the Islands or whatever. It was a joke, of course. They wanted to declare themselves nuclear-free zones the way New Zealand has. But I don't know what the answer is. I don't think anybody knows what the answer is. There's nothing in the Constitution about it, obviously. And so there'd have to be some either amendment to the Constitution. I suspect legislation alone would probably do it. But we're a divided country, but we're not yet there. I hope not.
So it's with the Trump impeachment, it's abundantly obvious, I think, to everyone involved, including the Democrats who are going after him, that they have no jurisdiction over a private citizen. But suppose they would be able to revoke his citizenship under some law that maybe was passed after 9/11 regarding national security or something. And if they were able to revoke someone's citizenship, would they then be able to try somebody for being essentially a terrorist?
Interesting question. Under American law, you cannot, under any circumstances, period, revoke the citizenship of a person who was born in the United States and who was a natural-born citizen. There's simply no process in law for doing so. You could have a man who murdered 1 million people. You can have a man who tried to overthrow the government. You could have somebody who committed the most heinous of offenses. The one thing you can't do is take away his citizenship. He can give up his citizenship by certain actions, but you can't take away his citizenship. You can revoke the citizenship of people who became naturalized citizens if you can prove that they obtained their citizenship by fraud. But if you were born a citizen, you will die a citizen unless you make the decision to give it up. That would probably be constitutionally compelled, but even if it were permissible by statute, there is no statute today which deprives a person of their natural-born citizenship. And, of course, a person can be called a terrorist even if he's a U.S. citizen. The United States assassinated a U.S. citizen who was engaged in propaganda in support of terrorism. And there was a big dispute about it. The ACLU said, no, you couldn't target a U.S. citizen. I took the opposite position, that the Constitution doesn't distinguish between a citizen and a non-citizen when it comes to preventive actions designed to protect the national security of the United States. Indeed, one of the Germans who was caught and executed as a spy in the Second World War claimed he was a U.S. citizen, and that didn't matter. He was still executed for sabotage and espionage against the United States. So citizenship issues are very interesting, but the bottom line is you can't take away a person's citizenship if he was born with it.
Alan, I just want to know if there's an appellate process for the hearing that's going on in the Senate. Mm-hmm. If they find him guilty, does he have a right to appeal automatically, or what's the procedure there? I don't know.
It's a great question, and nobody knows the answer. There are two justices, Justice Souter and Justice White, both former justices, who in concurring and dissenting opinions said there might be room for appellate Supreme Court review in extreme cases. I'll give you an example. If the Senate said, hey, we don't like the 2/3 requirement, we're going to vote to remove, impeach, disqualify, whatever, a president based simply on a 51% vote. I think that would be cognizable in the Supreme Court. On the other hand, if they decide to define bribery more broadly than others would, I doubt the Supreme Court would take that case. So I think it would require an extreme case before the Supreme Court reviewed an impeachment and removal trial of a president. I don't think this case is among them.
Hello, Professor Dershowitz. This is Chris Strawn in California. Hey, call me about the article that was published in Time this last week where, by the reading of some, it basically said, yeah, here's what we did. We used these shadow cabals to do X and Y and Z to sway the election, and yay for us, it worked. So I wonder what your thoughts are on that article and the specific items that it details that they were able to accomplish in an underhanded, shadowy, quote-unquote, sort of way.
Well, there's a difference between underhand, shadowy, and illegal. That's why I've suggested a voter integrity panel. The voter integrity panel would have broad jurisdiction. It could look not only into whether the election had elements of fraud or whether it was stolen, but also whether there were underhanded tactics used, and they would be publicized. And if it was done, if the voter integrity panel was used before or during the election, maybe they could even impose some remedies. After is a little bit more difficult. But, this election will be examined for a long time. History and historians and others will look into it. I think they will come to the conclusion that majority of Americans wanted Biden to be the president, and the majority in states with enough electors did it. I don't think this election was stolen or determined by fraud. Was there some fraud? Were there mistakes? Absolutely. I predicted early on that this would not be a perfect election. There's never been a perfect election. But do I think the outcome would have been different? I remain to be persuaded on that. I have an open mind, but so far I have not been persuaded on that, even by Time magazine.
Hello, this is Sarah. I am from Fulton County, Georgia. I just wanted to let you know that so many commentaries have dismissed the Georgia election fraud because they have seen no evidence. The evidence was presented to the Georgia Senate Certification Committee. It was filmed and posted to YouTube by NTD. You can find it by going to YouTube and searching Georgia Election Hearing, NTD Live, Georgia Senate Subcommittee. I challenge anyone and all who are interested to review this evidence. It's long, but it is revealing. So I found your podcast today, and I'm enjoying it tremendously. Thank you so much.
Well, thank you for your very informative call. People should go to that website. People should read everything. Look at all the evidence. Come to your own conclusions. The problem with America today is that we don't know who to believe. You watch CNN, you see one version of the world. You watch Fox, you see another version of the world. You watch Newsmax, you see another version. You watch CNBC, MSNBC, you read the New York Times. Nobody knows what to believe. That's why you have to go to primary sources if you're interested. And you've cited a potential primary source, and I think people should go and look at it. In the end, all Americans have the right to review the evidence and come to their own conclusions. Lawyers shouldn't be disbarred from making these arguments. Lawyers shouldn't be threatened by academics that the arguments will be frivolous. We need to open up the marketplace of ideas even more than it is today. We need to go back to the golden age of the First Amendment, where people were encouraged to speak their minds. Yeah, that means Nazis can march through Skokie. It's a price we pay. It also means Martin Luther King can march through Birmingham because the Constitution doesn't distinguish between good speech and bad speech, true speech and false speech. And so we need to get back to the day when we trust Americans to make all their own decisions based on the facts, based on information, based on reality. You're always going to hear facts. You're always going to hear objective, neutral, unbiased opinions on the Dershow. And I want to hear your opinions, even if they're biased, even if they're not objective. We'll discuss them. You have a right. You are the wits of the Dershow. You have the right to express your views. I will never censor them. I will always answer them on the Dershow. An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.